notes. Statements were not, they were the type that I'm related to the Pope, I'm not the father, not the stuff that, it was stuff that was beneficial to the defense, not the state. We didn't have the statement. Ms. Torres did not tell us the statement that if I can't have it, no one else will, that kind of thing. Then last Friday, Ms. Malcolm called us saying she wanted to talk to us, was wondering, since the defense had talked to her and hadn't heard from her, who was going to call her. So we went and talked to her on Monday. We were meeting with Dr. Burston, so we took Dr. Burston with us so he could see what she had to say, if there was anything of value. We went to her home. She told us all the statements that she testified to yesterday. That was Monday, and the only reason we were able to do that on Monday is because we didn't have trial on Monday. She explained to us that she told all of this, that she told us she had told to the defense attorneys and an expert, one of their doctors. And obviously she couldn't recall which doctor it was. She said there was about 5 people in the room, Mr. Williams, 2 female attorneys, a doctor, and she couldn't tell us who the 5th person was. I think that was consistent with what she said yesterday. The rule is to, that's cited by the defense in this case, is to make sure that the defense knows any statements the defendant makes and says who's going to make them and who's the person who's going to say those statements. That rule was satisfied. The defense knew what the statement was and who was going to say it when Ms. Malcolm spoke to them for over 45 minutes. The rules for notice, and the defendant had notice. Matter of fact, they had notice before the state had notice. You indicated yesterday you thought it was a technical violation. We respectfully disagree. We found no cases where there had been this kind of scenario where the defense knows the statement, we don't know the statement, and then we learn it later. But we did find this soliciting case, which we provided to the court, which is 717 Southern 2nd 205 1998 case. In that case, apparently an officer had not put in his report a statement made by the defendant, but he gave it in the deposition. So the state did not provide the defense, here's a statement not in a report by the defendant, because they already knew it. The case says the defendant, but this clear defendant was aware of the statement prior to trial, therefore it's not a Richardson violation, not a discovery violation. They knew about this statement prior to trial. It is not a discovery violation or Richardson violation. The rule is for them to know. They knew. They knew before we did. So they are claiming possible prejudice. We think we or the court should be able to voir dire their experts. At least one of them knew about it beforehand, before they testified, to see what they knew about it, and would it affect their opinion. To deny the admission of the statement is the most extreme sanction. The defense court can be allow the defense to reopen their case or put on sort of burden on the issue. They can truthfully claim that this is new evidence that came up during the trial, and their experts are not going to say it changes their opinion. At least one of them, it doesn't change their opinion because he knew about it before he testified. So we know at least one of them it won't change their opinion at all. The rules are designed.
Well, who knew about it before they testified?
She said one of their doctors. I can't tell you which one.
Okay.
But one of their doctors did before they testified. The rules are designed to give the defendant notice. They got notice. The rules are not for the gotcha moment. They made a strategic decision to move forward on this case with the hope that we wouldn't find out about those statements in the phone calls. When their strategic decision went south, they should not now allowed to be called surprise and prejudice. The strategy to proceed with hopes of us not finding out about the statements doesn't make them victims in this matter. Their strategy decision does not turn this into procedural prejudice. They hoped we would never find out. The rules are to prevent gamesmanship. They were hoping that we wouldn't find out. We found out. Now they want to claim victim and they want to claim foul. They shouldn't be allowed to do so. There was no discovery violation. They were fully aware of it. They made a strategic decision to proceed the way they did. When that strategic decision backfired on them, because we happened to find out about it, because Ms. Malcolm called us they should not be allowed to benefit from that. And Judge, I was handed a case, Eaton, 868 Southern 2nd, 650, 2004. The extreme sanction of excluding the evidence should only be used as a last resort. There are ways to cure this. The defense could be allowed to sit in through Ms. Kirsten's testimony, as we've allowed our experts to watch other witnesses' testimony, for instance, Ms. Torres. They could be allowed to watch that, and then they could be called to comment upon that testimony. They could reopen their case and present those experts. They could do them in surrebuttal. There are ways to avoid the prejudice that is hypothetical at this point. There's been no evidence that their experts were going to change their opinions or there's going to be any prejudice to them. It's a hypothetical situation, which is why we're requesting the voir dire the experts to see if they know about it. One would assume, once they learned this evidence, that they talked to their experts about it. And if they didn't, then at least one expert knew, and if they didn't, then their experts can consider that and make the proper ruling on this. Judge, the courts in Florida have held that the criminal rules are designed to prevent surprise by either the prosecution or the defense. The purpose is to facilitate a truthful fact-finding process. They were hoping we didn't know that fact. They were hoping we would never find out about that fact. And when we did, they now can't claim prejudice and foul and surprise. There was no discovery violation. The rules are they have to know what is going to be said and who said it. They knew that. Whether it comes from us or another source, they knew that. So just like the case in the deposition, they knew it before it came in trial, they knew it before now. They can't now claim procedural prejudice because their strategic theory and move and presentation backfired on them.
Let me ask you this. What about their argument that you can't use it because you didn't notice them that it existed, even though they knew it existed? They presumed you weren't going to use it because, and I agree, it doesn't really matter whether it's slick or ambushed, you're looking at the rules, because you didn't follow 3.220C. Because I think that's going to be their argument.
Judge, the rule isn't that the state has to know it. The rule is that they have to know it.
Well, this rule says any written or recorded statements and the substance of any oral statements made by the defendant. And it doesn't say anything about if they don't already know it.
But they knew it. Well, that's what in the listing case, they knew it too, because it was in a deposition and the state never gave that notice under 3.220. The state never gave that notice, and they said that is clear that they already knew it and it's not a discovery violation. That's as close as we're going to get because there is no case that's going to be found under this situation because it's not a discovery violation.
Okay, response?
Judge, the discovery violation occurs when the rule isn't complied with. We are now having a Richardson hearing, or had the Richardson hearing yesterday, continuing argument regarding the 3 prongs because a discovery violation happened. The violation occurs when the rule isn't followed. The rule wasn't followed. And so now the issue is whether it was inadvertent or willful. I would suggest that it was willful. If the state is indicating they got this information on Monday, they are of the belief that one of our testifying experts was aware of it, and then they cross-examined all 3 of our experts and didn't ask a single question about it. I would suggest that it was intentional, that they were intentionally not putting us on notice about it. They certainly crossed them about the other statement that we have contested and argued about, and they intentionally didn't ask any of the experts about that statement. And so, more importantly though, it's the prejudice. Regardless, even if it was inadvertent or willful, it's certainly substantial. The court, I believe, already made that finding yesterday. And it's already resulted in prejudice. There is no way for us to, we don't just go to our experts with every piece of evidence, obviously, the court knows that. We take them information that they need to consider informing their opinion. If we had information or believed that it was going to be evidence that was taken into consideration at trial, or that the state's experts was going to be provided, we would have certainly discussed that with them before calling them to the witness stand and having them render an opinion in the case. There's no way for us to fix the issue now. Like I said, there's the extreme possibility of one of our experts saying that they changed their mind, if it would change their opinion. But even if we were to call them in rebuttal, then it certainly, I mean, there's not a chance that it's not going to be insinuated or give the appearance that these people didn't have all the information when they testified. And that's not fair, it's not true. When the state had those oral statements, the rule says they have to give us those oral statements. They had not cross-examined a single one of those witnesses yet. They could have provided us those statements, called a timeout, let us talk to them, and this could have been cured. But it wasn't provided then, and at this point we've rested our case. And so I think the prejudice is great at this point, and I don't think there's a way to cure it by allowing this evidence in.
What is your response that it's not a discovery violation? Oh my, I'm surprised. When you obviously, I guess your position is we weren't surprised at her testimony, we're surprised that they're going to use it.
Correct.
Okay. Do you have anything that says that?
There is, well, all of the things that the cases that the state provided show that, well, the Brown case that from yesterday that I cited, where's my computer? But specifically in the case that the state provided, what's noteworthy here is they never objected. So there was never a hearing. So there's no discussion at all about the prejudice. And certainly the complete lack of mention of it would suggest that there was none. It was a statement that they were in a deposition together, the state and the defense, and they knew the statement was out there.
Well, the statement's pretty prejudicial. I should have killed her.
Right, but he had it in a deposition, and a deposition is where the state's present and the defense is present. So the state knew that the defense knew that the state was aware of the statement. Everybody's on notice that the statement is likely to come in because everybody's been present when the statement is discussed. If the state were to call me and say, I have a statement from witness X, and I say, oh yeah, really, I talked to witness X too. That is absurd to think that would be the end of the discussion. We would obviously say, what did witness X tell you? What did they tell you? Because you don't just say, well, I assume that they talked to him so they have the exact same knowledge I have. That is ludicrous. And so there's no way at this point, I mean, they said that they could have easily come in, discussed with us the statement, told us that, hey, we talked to Kirsten, there were some phone calls, are you guys aware of these? And they do know about the rule, Judge, because they provide us other statements in this case in accordance with the rule.
Well,
Officer Carter came in, gave them some statements the defendant had said in Invest and subsequently, and the state did the appropriate thing and immediately reached out to me and let me know there's some additional statements that Mr. Jonchuck made.
well, I think in this particular case, I don't think it was a willful violation. So they could get a heads up on you, because as I said yesterday, that would be really stupid given the situation that we're in. So I don't think so. Do you have, to me there's two issues here. One, is it a discovery violation if you know the contents of what we're discussing? Is
yes.
it or is, okay.
Because the discovery
Well,
violation...
let me tell you my other question. And do they have to notice you of a statement that you already know about? So I think those are the two issues. Mr. Ellis, do you think?
It's not a discovery violation. The rule is that they know about it, and the rule requires that they know what the statement is and who's going to say it. They knew what the statement was and who was going to say it. That's what the rule requires. The cases that they are citing or in this case, Officer Carter, that was something they did not know. If they do not know, you tell them. But if they know, we should have to tell them in this type of situation where in the middle of the trial, the witness contacts us and says, I talked to the defense for 45 minutes, I told them all of this. They know that. So we, we submit to court, it's our opinion, this is not a discovery violation. And I'm sorry, what was the second question?
If you're going to use the statement of the defendant, do you have an obligation, even though they know what it is, to provide it to them? Police report, report summary, any of those things, even though they know it. Do you have to say, okay, look, here it is?
Again, that goes with the discovery type of situation. And I think it's the same kind of argument. They knew about it. We told them we were going to call the witness. We called the witness the next day. After we told them, and we told them we were going to call that witness about 48 hours after learning about that witness, and they had known about that witness at that point for 3 weeks to a month. They can't claim surprise or prejudice or procedural prejudice when they knew this.
Judge, that would be the equivalent of them saying, we don't have to tell you about any of the defendant. I mean, operating under that theory, they would not have to relay any of the defendant's statements to us because they could just say, well, you're his lawyer. I'm sure you asked him what happened. Of course you know what he said.
And that's the point, Judge.
And that is obviously not what we have the discovery rules for.
And that's the point, Judge. If they don't know, we have to tell them. They knew. They played hide the ball. They got caught, and now they want to claim victim.
Further to
Well, I don't necessarily disagree with all that, but I don't know that that really matters in the final analysis.
It matters that it's not a discovery violation.
It does. The violation is the not providing it. The court then does the analysis for the Richardson hearing, the 3 prongs. The violation is it not being provided. Under the state's reasoning, they would have, we would, every time we get a client, we would say what happened, get their statements, and then to have to divulge attorney-client permission to make sure those are the same statements the state has.
I know what the argument is, I just don't know. I can't remember my password on Westlaw. I have it in my office. Okay, we'll take 10-minute recess and see what I find.
All right.
looked at many Florida discovery cases and Richardson's hearings, and I cannot find one case that deals with this issue. All the cases are the prosecutor.
Oh, I was just saying I have some.
Okay, let's see them. Let's
Okay.
see them. All
Rainy,
these are the defense didn't know.
okay.
Every single one. They didn't know.
And Brown v. State, that's 165 Southern 3rd 726.
Is that the case where they didn't give the statement in the subsequent case?
That one, it's a video, right, it's a video confession regarding 2 sales, and it was listed in one of the sale cases. They were in trial on the other sale case, and they said the fact that they were aware of the statement and it had even been provided in discovery in another case did not meet the requirement, and they found that it was reversible error. I'm sorry, we've
Is
gone
that
through
the fourth DCA case?
Yes.
Okay, yeah, because I got that.
And so that one obviously was a situation where they were aware of the statement, and in fact, it had actually been complied with in discovery in another case, and they still said, let me find the language. It said, in the instant case, the state committed a discovery violation, discovery violation when it failed to list defendant's video statement to police and its discovery submissions in this case. Florida Rule of Criminal Procedure 3.220 requires the state to provide names of witnesses present when recorded or unrecorded statements are taken from or made by defendant, and to provide any written or recorded statements made by defendant together with the names and witnesses of the statement. A defendant is entitled to rely on the accuracy of the information disclosed by the prosecution pursuant to a discovery request under 3.200. The failure to give all of the required information is a discovery violation. Moreover, the fact that the existence of the statement was previously revealed to the defendant does not mean that the state complied with the discovery rules. And that case I'm going to cite to you next. It cites to a case, and I'll get to that one next. It says a defendant is procedurally prejudiced, excuse me, if there is a reasonable possibility that the defendant's trial preparation or strategy would have been materially different had the violation not occurred. Trial preparation or strategy should be considered materially different if it reasonably could have benefited the defendant. And so in that case, it was actually provided in discovery. It was 2 drug sales that he was arrested at the same time for, and the content of the statement was regarding that he had sold drugs at that Burger King on 2 different locations. So I think that's a lot more than we have in this case. And they said that that was not okay. Then looking at DR v. State, that's 588 Southern 2nd 327. That's 4th DCA from 1991. And that one, they're in trial, and a statement is elicited that had not been provided, and the state said, well, we mentioned this statement at one of the hearings, so the defendant was on notice because we mentioned the statement, and the court said that did not satisfy the requirement. It said that the state contends on appeal that the defendant was aware of the existence of the statement Dotson gave to the police because it was mentioned during a waiver hearing less than 1 month before trial. It also points out the substantial evidence against the defendant. The state then argues that any error was harmless. The state's argument must fail. The fact that the existence of the statement was previously revealed to the defendant does not mean that the state complied with the discovery rules. It goes on to state what the rule says. The state had an affirmative duty to disclose to defense counsel the existence of Dotson's statement and allow him to inspect, copy, test, and photograph the statement. They failed to do so. Whether the existence of the statement was later revealed at the waiver hearing does not alter the Richardson inquiry requirements when a discovery violation has been alleged. And then there's looking at Rainey v. State, 596 Southern 2nd, 1295. That's a second DCA case from 1992. That is specifically regarding an NGRI defense. The witness was listed. No statements were provided. The state responded that the defense was aware, or that the witness had been listed for a long time and had an opportunity to depose them. They said that that did not cure it, and actually went so far as to, let me pull up the language real quick. It said the trial court commented that the testimony might be prejudicial, but it was not grounds for a mistrial. We disagree. The appellant had a strong insanity defense, which was completely undermined by this discovery violation. We believe there was no remedy other than a mistrial, and the trial court erred in failing to declare a mistrial.
Can I see that?
Yes, ma'am. This one, the Rainey case is insanity, doesn't reference that the defendant had prior knowledge of the statement, though.
Judge Downey. That's not really what we have here.
Did you want me to pull up either of the other ones?
Well, if you think they're relevant, I mean, I got that.
Okay. Here's the DR.
What about the Celestine case? The paragraph.
Well, I think the issue is that if we take just, one point of law in a vacuum, but we have cases that have facts analogous to ours, and so it seems...
Go ahead.
I mean, the facts where the defense is aware of the information, but the discovery rule was violated. And so the whole point is that the trial preparation and strategy would have been different. The state continued to use the phrase in their argument that because their presentation backfired. They are acknowledging that we are now prejudiced. Their presentation backfired. How many times did Mr. Ellis just say that? They are acknowledging that we are prejudiced now. And so in the Celestine case, there's nothing to suggest that defense has the burden of proof in this case. The statement is, they concede that it was taken in a deposition where they were both made aware, and there's nothing to suggest that it was nearly as prejudicial as where we are here. We have the burden of proof in this trial, Judge. And so it's, I would argue, even more prejudicial than in a regular case where we don't have anything to prove.
Mr. Ellis, did I hear you right? Are you suggesting, before I make a ruling, that the defense experts should be proffered as to how that would change their testimony?
Yes, Judge, I think that they should be more dire regarding, do they know about the statement? If they don't know about the statement, get that statement, consider that statement, how that statement would affect them.
I think I need to do that.
Well, Dr. Otto is in Atlanta.
Can he be reached by phone?
I think he's teaching a conference. I don't remember, what
Well,
was
I mean,
that conference?
he's
No,
got
it
a
was
cell
a
phone.
training the other day. I mean, I can try
These
to.
people at I mean, I think that's the wise course of action. I don't think it's clear.
So, I
Other
mean,
than
well,
this paragraph right here. None of these cases are right on point with the situation we have here. And I have to weigh the prejudice, and I have no idea what the prejudice is gonna be.
Judge, we have a case in Brown. It is a recorded statement that the defendant admits to 2 crimes. He is arrested for those 2 crimes at the exact same time. He admits to committing the 2 crimes in that statement. That statement is listed as actual discovery and provided to the defense in the other case. The one case going to trial, they go to introduce it. They say that could have, there's no way we can't say that it wouldn't have affected their trial strategy.
Again, Judge, that's something that the state knew about beforehand. We didn't learn this in the middle of trial.
I understand.
But they learned it prior to cross-examining our 3 experts and prior to us calling you.
I understand that. I think the wise course of action is to take Mr. Ellis up on his suggestion and see.
Oh, the only thing is obviously we would request an hour or so to try
Well, I
to get in contact
understand.
with them and discuss it.
You don't have any problem with a cell phone?
No, Judge.
Okay, so just however they can be reached.
Right, but we need time to consult with them, obviously.
I understand.
First, okay.
Okay. So,
I think they're entitled to whatever time they need, Judge. I'm not asking them to be rushed.
okay. I am.
I appreciate that, Judge, but I want it on the record that this.
And Iberia is the only case that comes close to, I understand the Brown case, let me find that Iberia case again, addressing the, I don't even know.
Do you want,
I'll find it somewhere. Well, I think we gotta do the proffer or voir dire or what anybody wants to call it. So, let's talk about what to do now, how long. There's nothing else you can put on, right?
We're getting ready to put on experts.
Right, okay.
I don't think that that's until this issue's resolved.
1 o'clock? It's 2 hours.
Well, we'll each take an expert and we'll do our very best.
Well, let's do more than that.
Do everything within my powers.
Does that's 1 o'clock? I think that's the best as we can do. I don't think it could be any sooner.
no, I certainly don't think it could be any sooner. My thought was, should we send the jury home? We come back at 1 to do the, because they want to do proper testimony. So then we come back at 1 and then we're going to do how many hours of testimony? I don't know.
I know I'm in charge, but what do you think?
That's not really a reasonable request, but again, that's leave it up to the court.
All right, I think I need to send them home. We've already been sitting there for an hour and a half. Let's have them come in, please. And then Monday, we can start at 11 in the morning.
11?
Jury's in the jury box and seated, Your Honor.
Thank you. Good morning, ladies and gentlemen.
Good morning.
The issue that arose just as we started Ms. Malcolm's testimony yesterday has become complicated and difficult. We've been in here since 9:30 this morning dealing with it. We're going to have to deal with it again this afternoon, and there's no point in you all sitting here. So, you have today off. And be nice if you knew that before you got to the courthouse. And Monday, I have a morning calendar, and we're going to start the trial at 11 o'clock. Okay?
Okay.
Any questions or comments or anything? No? Thank you.
Thank you.
Have a nice weekend.
Have a good weekend.
Thank you.
Yeah.
Jury's at the hearing in court, Your Honor.
There's another case I pulled. It's a United States Supreme Court case from 1988. And it's, the lower court precluded the defense witness because of a sanction for violating a discovery rule, which is different than a state witness. But it talks about ambush and fairness and integrity, search for the truth, and the harshness of excluding testimony because of a discovery violation if there's some other way to remedy it. My belief is the testimony is very damaging to the defense, and I think equally that testimony to exclude it would be very harsh to the state. So if there's any way possible, I'm going to try to find it. Okay, but if I can't, I can't.
I can have the site for that.
Taylor v. State, 108 Supreme Court 646, 1988. It's really not on point except for the verbiage in it about, but I don't think it really probably has any relevance to the situation. Anything else anybody wants to say?
Your Honor, I was just suggesting to Mr. Bolin, I was taking notes yesterday, of course, during Ms. Malcolm's testimony. I don't know that I have it exactly accurate. I don't know if it might be of benefit.
I took good notes.
Okay, well, may I compare? Or I could ask,
Well,
if
let's
we
do
could
that
have it
later.
read back or something.
Well, I think we all pretty much agreed that the 2:30 phone call was the huge
No.
problem.
Our question is, in other words, we have to give that information to our experts, so we just want to make sure we're giving.
Oh, you mean all the phone calls? Or
Well-
just the 2:30 phone call?
Particularly the 2:30.
Right, I think that's the big issue.
Yeah, so I just want to make sure that when we're reporting to our experts.
Well, my notes say that, he called, he doesn't know what to do. I don't know how I can live without her. If I can't have her, nobody can. That's basically what I have.
I was missing one phrase, I don't know how I can live without her. And I also had in my notes that he said something about protecting her from this craziness.
That I don't know, I didn't write it down.
You guys have that?
Got that statement?
That was one of the calls, I don't remember which call, I mean.
Can you do a readback of her testimony?
I'm gonna have time to review it for a few minutes.
Huh?
I have a few minutes to review it.
You just do a rough one.
Let me find it. I don't know.
Okay.
Yesterday pulled up.
It was at just after,
It was the end of the day before they went home.
yeah,
Yeah.
just after 4:10.
Let me figure out which file it would be.
Is that?
I just Which phone call are you specifically referencing?
The fourth one, 2:30.
Okay. About 2:30, what was the contact of that call? He was very down at that point. He was explaining that he didn't know what to do anymore. He wanted to protect her from this craziness, you know. I don't know what I would do without her. If I can't have her, then no one else will. Is that the one?
Yes.
Okay.
Do you want to do it again? You want her to do it again?
Yes, please, just a little bit slower.
I'm sorry.
I had something out of order. Oh, that's unusual.
Okay. He was very down at that point. He was explaining that he didn't know what to do anymore. He wanted to protect her from this craziness, you know. I don't know what I would do without her. If I can't have her, then no one else will.
I don't know.
What I would do without her.
What?
If I can't have her, then no one else will.
Read that again. I do not know how.
Wanted to protect her from this craziness. I don't know what I would do without her. If I can't have her, then no one else will.
Okay. Okay, anything else as far as what you need?
If we are unable to have somebody here at 1, do you want us to call
So-
chambers ahead of time, or, I mean, we should probably be able to have somebody here, I just don't know that everyone will be
Well,
available.
let's reconvene at, we'll say 1:15 and just see where we are. Okay?
Okay.
All right.
And if we can have witnesses here, you want
That's,
them here?
yeah, or on the phone, yes. Okay, anything else?
They're up.
Just one.
Judge, can we waive Mr. Jonchuck's presence for
Of
this
course.
afternoon?
Is that what you want, Mr. Jonchuck?
Yes, ma'am.
Okay, sure, okay.
All right. We'll be recessed till 13.
objecting to the court conducting a proffer of any of the experts.
I figured that was coming.
So that's what those
Okay,
are about.
that's what they're about, okay.
We have one on it, it's on 802, 7 442, and it's Portner. This is regarding the original issue, the prejudicial discovery violation, not offer. Judge, do you have Westlaw there? I have one more case, but I don't have copies. Do you want me to have them brought up?
I know my password.
Okay.
And I actually remembered it.
One more trial, or one more case on the prejudice issue also.
That's what I should look up.
If you, whenever you have a chance. It's 802 Southern 2nd 442 Portner, Portner, Key State.
That's not what those cases stand for.
Okay, I didn't read it, okay.
And my understanding of those cases would stand for, we can't necessarily, at best, the cases stand for, we can't ask them when they learned of this, did they discuss it with their attorneys, that kind of thing. They're talking about attorney-client privilege and work product. But I don't see anything there will prevent the court from, does this change your opinion? How does it affect your opinion? The statements that were elicited by the witness, they can't create error, the issue, and then rely on invited error and benefit from that invited error. The court is trying to at least restrictive means, is my understanding, other than excluding the testimony. The only way to do that is they are claiming they have some kind of prejudice. They haven't shown it. They have to, if their witnesses are not going to change their opinion, then their witnesses can testify to that. If the court wants to keep out when they learned of that testimony, other than from the witness on the stand or just recently, that's a decision the court can make, but it doesn't change the fact that the court should be looking for the least restrictive means. We're still back, obviously, arguing that it's not even a discovery violation, but if it is, if the court finds that it is the technical one, then the court should not exclude this testimony, and their experts should be given the opportunity to review that evidence and make a finding on that evidence. This is not inquiring of attorney-client privilege. This is not work product. This is not any of those situations. This is new evidence in which they are allowed to review and make a decision on.
What do you say to that argument? I haven't read the cases yet, but it makes sense.
It doesn't make sense at all, Judge. We do not waive any confidentiality with an expert witness until we call that witness to the stand in trial.
I would agree with that.
Had we had that information, we may have never called any of those witnesses to the stand. Certainly, Otto and Mayer hadn't been called yet. Dr. Mackless was mid-testimony, but there's a real good argument that Dr. Mayer and Dr. Otto would have never even been called. We would have never waived that confidentiality. So to say now that because of the discovery violation, confidentiality was waived and now we can inquire of these people essentially what work product would be is improper. The proper route is, I mean, we obtain information, we make a strategic decision among the team whether we're going to provide that information to an expert. Then we have strategic discussions with the expert regarding that material. To say that we're going to just all go through that process together in open court violates Mr. Jonchuck's right to a fair trial. To say, okay, we're going to have these confidential communications with the state attorney present, with the court reporter present, with the judge asking questions of the witness.
I agree. I'm not going to do that. I'm not going to require their experts, their change of opinion in a public forum as to this new piece of evidence. Mr. Ellis, I can't get around Ibera where the defendant's statement to the officer was used in impeachment, and obviously one could argue that the defense counsel may have known that, they may have not. However, the rule requiring discovery of the defendant's statements applies equally when the statement is used for impeachment purposes. The error is harmless only when the state can demonstrate beyond a reasonable doubt that the aggrieved party was not procedurally prejudiced by the violation. So to me, the burden falls on you. The Celestine case mainly addresses the fact that there never was a Richardson hearing, and there should have been. You can't really tell, because apparently there was some kind of motion to suppress here. There's no data on the fact that you're stating it here today and have said it in your deposition, correct? The trial of interrogation. Okay, so nobody ever even argued that. case is from 1998 from the 5th District. So it was never really argued, and there's this little paragraph, and I agree with you that they said that although the statement didn't appear in the written reports, it is clear the defense was aware of the statement as evidence from the testimony of Corporal Ashley that he had disclosed this information in his earlier deposition. So I agree with you that this says what you're saying, that you can't claim a discovery violation if you were already aware of it. However, these other cases don't agree with that. I mean, Brown versus State, 4 DCA 165, Southern 3rd 726. I mean, they're kind of an unbelievable case in a way, that it says they knew about the videotape, they used it in a prior trial, this is the next case, and it was a discovery violation because the state didn't tell them they were going to use it, and clearly they knew about it. And I'm trying to find, there's one more, I think. Maybe not. So, I think it's a real problem. I wish it wasn't a problem. I think it's, I agree with you. I think the statement is a statement that is extremely important that the state put in front of the jury. But I also agree that the defense is highly prejudiced. It's a killer statement.
What about this argument, Judge? If we met with the witness on Monday and gave that information to them on Monday, like they're suggesting we should have done, I think they could still make the same argument that they're prejudiced, even though we just learned it in the middle of trial, because the jury had been sworn, the experts had been selected, the experts had already formulated their opinion prior to trial and given depositions in the case, so I think they could still make the same arguments even on Monday.
I mean, maybe, but we're not on Monday. Maybe, I don't know. I don't think I can let it in. It's not because I don't want to let it in. Shouldn't say that, but I don't think pursuant to these recent cases, I can let it in. I mean, you would have to show me why they're not procedurally prejudiced. And I don't know how you can do that. And I think the other statements can come in. I stick by that because I don't think they're prejudicial. Those other phone calls.
Judge, you can't let, we'll complete this, you can't let some in and not, if it's a violation, it's a violation to all of them.
Well, that would be your decision then. If you wanted to get in the other ones, I'd let you get into them. Because I don't think those other phone calls are prejudicial. And I think one could argue that they're beneficial to the defense. And another way to look at it too, it doesn't really matter because their experts haven't testified about it, is that it's a further symptom of his mental illness. It could be argued that way too. But it could certainly more strongly be argued the way you want it to be argued. And I don't think I can. I want to, but I don't think I can.
What about the fact that one of their experts knew about it, testified, and never mentioned it?
What difference does that make?
Is that a discovery violation on their part? And if so, could we call that expert to the stand and question them about it? They had this information, they relied on it, they
Well, I guess
reviewed
that's something that we could take up during the flow of the trial. I don't have to make that decision. The only decision I'm making is what Miss, whatever her name is, Malcolm, can testify to, not right now, but Monday morning.
Right, I understand. That may be something we may ask if Your Honor rules that way, that we would be allowed to.
Well, I'm ruling now. I just don't know how other way I can rule. So that's how I'm ruling. Okay.
Obviously, we object to it, Judge.
I know.
They're inviting error. They created the situation, and because they created a situation, they want to now be able to benefit from the error that they created.
I don't think they created the error. I think it was an inadvertent slip up on your all's part. I don't think it was intentional, but I don't think they created it. They didn't do it. They didn't have an obligation to do anything, but you did. So, do you want to do this other motion? Defendant's motion to reconsider the court's ruling?
Well, 30 seconds.
To do it any other way would be, in my opinion, intellectually dishonest. And you sometimes, hold on, you shouldn't try to see how you can do something to benefit one party or another, but I think we're all guilty of it sometimes. But there's no way, in my opinion.
And I still don't understand, Judge, how that information cannot be presented to their defense experts, and the defense experts make a decision on it. If they sat through the trial and it came up during the trial, they could watch witnesses, as experts always do. They can make that decision. That's not going into attorney-client privilege. That's not going into work product. That's information, that newly found information that they can make a decision on. I don't see how that is prejudicial.
It is because the confidential experts,
They're not confidential.
the expert's opinion is not subject, shall we say, to cross until it's used, and they're not using this because they didn't think they were going to need to. There's no way that I would force the defense to put their people on the stand and say, okay, what about this? What do you think? I'm not going to do that. Okay, so are we hearing the other motion or not?
I need a second to redirect. I was researching all the other stuff and
Well, I
trying to
think
get
this is going to be pretty short. I'm not inclined to revisit this out.
Okay.
I think I made the right decision. So I'm going to deny that. Okay. So.
Can I just put some cases on the record?
Sure, sure.
Sorry, Judge.
That's okay, we got all afternoon. I don't think you have any remedy at this point. No, I'm talking to the state about the other discoveries.
So regarding.
Right, hold on a second.
I'm sorry.
I don't think you do.
Well, before when I was talking about calling the witness, I meant calling their witness to the stand, and I don't think I was clear about that.
Well, that's fine.
Okay,
You can do it that way.
that's what we'd like to do.
Yeah, I don't think there's anything that,
Well, I think there would still be the issue with Otto and Mayer because confidentiality was waived after the discovery violation occurred. So I think there's an argument that confidentiality may not have been waived. They would not have been necessarily put on the stand if we had been provided that information. And it would, I mean, it sounds like they would be calling to discuss work product because we are only required to disclose to the state information that we provide that our expert relies upon.
I think you would be allowed to ask if they knew of that. Are you aware of this?
That would be, it would be improper for the witness to answer that question because that would violate work product. That is a strategic decision, whether somebody was aware of it and it was not called. There's no way that that does not get into the strategy of a team, whether somebody was aware of information and didn't say something about it or not, I mean, that's getting into the strategy. If they relied on that information, we have a discovery obligation that we are aware of and would comply with, most certainly, if we had an expert that relied on that information and their opinion was changed, or they relied on the information informing their opinion.
I understand, but what is wrong with the question, were you aware of this?
Because that gets into confidential communications.
But it doesn't.
It does though.
How does it get into confidential communications? They're either
If they
gonna
say, and
yes or no.
if they were made aware of it before the state disclosed it,
Well, they never disclosed it.
right? So that's all.
Well, I don't have to decide that today, right?
No, you don't decide today.
Okay. And probably not even on Monday.
Probably not.
All right. So you can go ahead and put whatever you want on the record about the
Okay.
CLR.
Judge, we filed a motion for reconsideration regarding the court's ruling on the term psychopathy or psychopath in reference to the PCLR. I have provided the court and state with State v. DEMENIUK. That's at 888 Southern 2nd, 655, a 50 CA case from 2004 that discusses that Fry requires the judge to perform the function of gatekeeper, that the admissibility, the gate of admissibility is not opened unless the proponent of new scientific evidence can demonstrate by the greater weight of the evidence that the scientific principle upon which the evidence is based and the testing procedures used to apply the principle to the facts of the case have gained general acceptance for reliability among impartial and disinterested experts within the particular scientific community. According to Dr. Burston's testimony during the hearing, Dr. Lazaro's testimony during deposition, they did not, this is not pure opinion testimony. They both relied on the administration of the Psychopathy Checklist Revised, which takes it out of the realm of pure opinion testimony. I think LeBron discusses that, where if you combine opinion and a instrument or some kind of testing or a database, then it makes it no longer pure opinion testimony. All of the research suggests, including the testimony of Dr. Otto during trial, Dr. Burston during the motion, that there is no research or anything to suggest that the PCLR is certainly not a preferred nor even a recommended instrument that should be used in determining mental state at the time of offense. The LeBron case, I'm sorry. In the Demunic case, the defense was, this is a first-degree murder. Defense has raised the issue of insanity. The defense sought to elicit testimony that the antidepressants the defendant was on caused the defendant to self-medicate to treat her depression, which caused her to ultimately be intoxicated and commit a murder. The state fought to exclude it. The court held, well, it's kind of confusing. It's kind of similar to what happened here. There was a hearing set, but only part of the hearing happened. Then at the hearing, the defense called one of their doctors, testified for about 5 hours. When the state cross-examined the doctor concerning the studies he relied on in reaching his opinion regarding the effects of the antidepressants, the witness related that he based his opinion on 2 studies regarding premenstrual syndrome that were undertaken in 1992, 1993, and on a 3rd unpublished Scottish study regarding depression suffered by some women during premenstrual time periods. He agreed that he had not personally been engaged in the research trials of the drugs, but said that he used the results of that research in his clinical practice. Finally, he said that he also relied on a healthy volunteer study conducted by another doctor. That hearing was convened. The court came back and said, I'm going to allow that, and we don't need to have a Fry hearing because it's pure opinion testimony. The state filed a writ, and the appellate court said this is not pure opinion testimony. Once they have used these other things, it becomes then a Fry issue, and specifically they needed to conduct a Fry hearing because the witness, per the witness's own testimony, there was no studies to suggest that this was a thing, which is exactly what we have here. Dr. Burson's own testimony suggests that the PCLR is not recommended or suggested to be used in the determination of mental state at the time of offense evaluations, that there is no literature. He actually testified that would suggest that. Dr. Otto indicated the same. That's a Florida Supreme Court case from 2017. In that case, the defendant was seeking to introduce a specific kind of brain scan into evidence. They, at the Fry hearing, the proponent of the evidence bears the burden of establishing by preponderance of evidence. At the Fry hearing, the doctor that the defense had wanted to call testified about peer-reviewed studies that used that specific scan having been used in comparing individuals to normative databases. He testified about the software used. He'd been using it since 2005. He indicated that that it's registered with the FDA and that registration establishes the appropriateness of the NeuroGuide analysis to be used by qualified medical or clinical professionals for the statistical evaluation of human EEG. He also indicated that there was a 400-page abstract he had reviewed with 795 peer-reviewed journal articles, and said that between 130 and 150 of those 795 articles supported his subfield about using that scan. He indicated that the weight of that evidence at the Fry hearing established the general acceptance. The court, the Supreme Court said no, that didn't satisfy Fry. It says two other witnesses that testified at the hearing and stated the QEEG was not generally accepted as a means of diagnosing brain damage. He admitted that it was not proper to diagnose brain damage based on the QEEG data. Further, there was testimony that pictures produced were misleading because they colored large areas of the entire area. And so they ultimately said that this did not pass admissibility under Fry. Then just to cite Murray v. State, 838 7th 2nd, 1073. That's Florida Supreme Court case from 2002. Fletcher v. State, 168 Southern 3rd, 186. That's Florida Supreme Court from 2015. That case discusses testimony that was admitted regarding the PCLR. Interesting, they say something. The defendant had called a mental health expert. This is in the penalty phase of a capital case. Called a mental health expert who testified. That expert testified that he had antisocial personality disorder. They said that Fletcher did not open the door to lack of remorse evidence by calling an expert who testified generally that he suffered from antisocial personality disorder. The court has repeatedly held that a diagnosis of antisocial personality disorder does not permit this type of testimony. Specifically, in Atwater, the court stated that a trial court errs in permitting the state on cross-examination to ask the defense expert whether the persons with antisocial personality showed remorse. In fact, this And so in our situation here, one of the characteristics in order for them to discuss and cross-examine the PCLR, remorselessness is an actual condition, and it said there was, they ultimately found that there was no reasonable possibility that the reference from that doctor's testimony, he improperly testified about the lack of remorse, but ultimately said that it wasn't, or that it was harmless error. But says, nevertheless, we caution the state to take precautions to prevent a reoccurrence of this problem that arises when a defendant permissibly offers a diagnosis of antisocial personality disorder as a mitigating circumstance. As we have stated, this type of evidence in itself does not open the door to the state rebutting the testimony with questions about lack of remorse as a feature of the disorder, and all of the things that are a feature of the disorder that they intend to introduce carry that same prejudicial effect. I also have provided Chavez v. State, 12 Southern 3rd, 199, Florida Supreme Court case from 2009. This is again going through the process that the court is required to entertain before admitting the expert testimony. This requires the court to make, it is within the court's discretion to determine the qualifications of a witness to express an expert opinion. This determination will not be reversed absent a clear showing. Before an expert may render an opinion, the witness must satisfy a 4-pronged test of admissibility. The section requires the court to make 2 preliminary determinations. 1, whether the subject matter will assist the trier of fact in understanding the evidence or in determining a disputed fact. And 2, whether the witness is adequately qualified to express an opinion. Once those 2 threshold determinations are affirmatively satisfied, 2 more requirements must be satisfied for the admission of expert testimony. The expert opinion must apply to evidence presented during the hearing, and the danger of unfair prejudice must not substantially outweigh the probative value. And so in that case, for the expert to testify about the PCLR, it would be improper for them not to get into what that is. And there's no way for them to do that without then the prejudicial effect outweighing any minimal probative value. And then looking at Ramirez v. State, 810 Southern 2nd, 836. This is Florida Supreme Court case from 2001. This one is this is the case that came back like 4 times. They refused to have the Fry hearing. This is a tool mark identification evidence, and the state said, well, we've been doing tool mark identification for years. It's always passed Fry, and which is kind of the situation we have here. While the PCLR has been approved as passing Fry in future dangerousness or risk assessment, there is nothing to suggest that I have been able to find that the PCLR has passed Fry for the purposes of a insanity at the time of offense or mental state at the time of offense. I haven't been provided anything from the state. If they have anything, I certainly haven't been provided it. I have looked for years now and have been unable to locate that. In this case, it was, so traditional knife mark evidence is a subgroup of the broad category of evidence commonly referred to as tool mark evidence. The underlying tool mark evidence, which is explained below, is generally accepted in the scientific community and has long been upheld by courts. However, this witness, it says Hart's theory, which was the witness that the state was calling to introduce in this case. Hart's theory of knife mark identification, however, departs from traditional knife mark identification theory in significant ways, and the state has cited no appellate decision upholding his theory. They which is what we have here. Yes, insanity evaluations have been going on for years, and PCLR evaluations have been going on for years. However, using the PCLR and testifying about somebody's mental state at the offense is not recognized in the field and in the expert field. The court ultimately had Hart's testing procedure is based on the premise that every knife blade is unique due to microscopic imperfections in the steel caused by the manufacturing process. These imperfections leave lines or striations when a knife is plunged into human cartilage. Because cartilage is relatively firm, it retains the marks. They go through the following technique that Hart implies. It says, according to Hart, a technician's ability to identify the similarities in casts is developed by training and is passed on from one technician to another in the workplace. A match under this method is declared if there is sufficient similarity. This determination is entirely subjective. It's based on the technician's training and experience. There is no minimum number of matching striations or percentage of agreement or other objective criteria that are used in this method. No photographs are made of the cast, Hart explained, because laypersons No photographs are made of the casts, Hart explained, because laypersons and those not trained in this procedure would be unable to understand the comparison process. Similarly, no notes are made describing the basis for identification. Once a match is declared under his theory, no other knives are examined because an identification under this method reportedly eliminates all other knives in the world as possible sources. There is no objective criteria that must be met. There are no photographs, no comparisons of methodology to review, and the final deduction is in the eyes of the holder, i.e. the identification is a match because the witness says it is a match. They said during the hearing, they ultimately, the Supreme Court said that this fails the Frye test. It says, although several of the state's experts, I think the state ultimately called 3 experts or something during the hearing, although several of the state's experts testified that the underlying principle employed by Hart is generally accepted in the field, we conclude that this testimony, standing alone, is insufficient to establish admissibility under Frye in light of the fact that Hart's testing procedure possesses none of the hallmarks of acceptability that apply in the relevant scientific community to this type of evidence. This is particularly true in light of the extraordinary precise claims of identification that Hart makes under his testing procedure. And so they held that it was, after going back multiple times to actually have the Frye hearing, that did not pass Frye. And that's something as simple as tool mark identification, which certainly could pass Frye for other means. And then finally, Judge Williams v. State 779, Southern 2nd 314, second DCA case from 1999. In this case, the state sought to introduce an expert witness regarding battered spouse syndrome. This was a sex spat. The defendant, I think, was an ex-husband of the victim or estranged husband of the victim. The defense was consent. The state filed a notice of intent to introduce expert testimony that the victim lacked the ability to consent to sexual intercourse with the defendant because she suffered from battered spouse syndrome brought on by the previous beatings of Williams. The defense sought to exclude the evidence, indicating that the defense sought to exclude the evidence, and argued that battered spouse syndrome evidence is novel, has not been recognized as a mental defect, and recognized as passing Frye for the purpose of proving consent. The court ultimately agreed with that. They said yes. Barbara Stein ultimately testified over the defense objection. that the victim suffered from post-traumatic stress syndrome caused by the defendant's prior beatings, and from battered spouse syndrome, which causes the victim to adjust her behavior to avoid abuse. Dr. Stein recited as the basis for her opinion numerous incidents of discord between the defendant and victim, described in detail the victim's history of being harassed, intimidated, and physically and emotionally battered by the defendant. Further testified that as a forensic psychiatrist, she uses techniques to detect whether a victim was exaggerating or lying. The defense objected several times during the testimony, moved for a mistrial, arguing that Stein was improperly vouching for the victim's credibility. They ultimately said her testimony, which lasted about 1 hour and 40 minutes, became the primary feature of the trial, and ultimately said that the court had erred in denying the defense motion in limine to exclude that testimony. They said, although Hickson holds that the battered spouse syndrome meets the Frye test and is admissible to support a defendant's claim of self-defense, we do not believe that Hickson stands for the proposition that such evidence passes the test for all purposes. They cite to Ramirez again that the Supreme Court has said the burden is on the proponent to prove the general acceptance of both the underlying scientific principle and the testing procedures used to apply that principle to the facts of the case at hand, and indicated that the state had to prove not only the general acceptance of battered spouse syndrome in the relevant scientific community, but also that the testing procedures used to show that a person diagnosed with battered spouse syndrome lacks the ability to consent to sexual relations with the batterer. We are aware of no scientific basis to support a conclusion that battered spouse syndrome robs a person of the ability to consent, and none has been presented to us to consider either. So they held that that actually said we didn't even get to Frye because the testimony failed to pass the 4-step test, which although I think in our situation we have plenty of evidence. In fact, the only evidence that has been elicited is, yes, I use this in forming my decision, but agreeing that it is not widely accepted in the scientific community to do so. Dr. Burston testified, we expect Dr. Burston and Dr. Lazaro to testify that certainly I believe they would be allowed to testify as to whether he was insane at the time. I think they are both intending to go one step further, indicating that he was not insane, but rather the homicide occurred as a intentional, premeditated killing, consistent with his finding and her finding of psychopathy, psychopath. Dr. Burston does actually use psychopath multiple times in his deposition, and that is a direct result of that. There is nothing that would suggest that that has passed Frye before. I've asked numerous times if the state has anything, just as recent as yesterday again, and I've not been provided any information that Frye would, or that using the PCLR and the determination of mental state at the time of offense is accepted in the relevant scientific community.
If I recall the motion to exclude the PCLR, Dr. Burston, who else testified other than Dr. Burston?
Dr. Burston and there was a bunch of research articles admitted as evidence.
Testimony was only Dr. Burston.
Right, that's what I thought.
But the articles were admitted as evidence.
They were?
The articles were. There was an affidavit that the court did not admit as evidence that I did file along with this. But the actual research articles were admitted.
They might have been because I think I said I read them, so.
They were filed with the motion, Judge. I don't recall them being put in evidence, but I know they were filed with the motion before it was even heard.
You did not put on any experts to establish what you're trying to establish. You're talking about what Dr. Otto testified to in the middle of the trial.
which is why we're renewing it. Correct, we do not have a burden. The case law is very clear from Ramirez, from the Supreme Court case, through Ramirez, through Chavez, through everything, that the burden is on the proponent. And so, correct, we did not call any witnesses. Dr. Burston's testimony was that it is not used for that, and the evidence that was introduced was not, it was not used for that. Dr. Otto has additionally provided testimony now in trial, additionally saying that this is not widely accepted in the scientific community.
If I recall, I have my notes back there, but I don't have them in here. Dr. Burston testified that as part of his findings of antisocial personality disorder, he used the psychopathy checklist, or I think some other expert referred to it as an asset list or something, to corroborate his diagnosis. And there was also mentioned, and I don't remember without looking at my notes, some change in the DSM-5, which suggested that was a course of testing somebody could follow. But I'd have to look at my notes.
And the issue is not whether antisocial personality, I mean, there's a bunch of inferences that have to be made there. So, one, we have to, just because a doctor or an expert uses it, that does not make it admissible. That's what we're saying. His opinion is based on that. It is not pure opinion testimony because he does use the PCLR. And so we are saying that PCLR has not passed the Frye test in hearings regarding mental state at the time of offense. Whether he uses it or not, that's not the point. The point is, in order for that testimony to come in front of the jury.
Well, if it's somehow suggested in the DSM-5, and I don't know, that would certainly be a source that he would use to say, you know, I'm going to look at these features, and this is an assessment tool I can use to do that.
So it's the alternative. Yes. It's the alternative, not the actual DSM. What was accepted into the book. They have an alternative theory.
Something.
Right, they put an alternative theory in, but it didn't make the actual cut into, these are still the diagnoses.
That's what this, Judge.
I'm listening. Let me go get my notes.
I'll give you the transcript.
Oh, okay.
Can I approach the case, Your Honor?
Yes.
This is the one that you told me you had? The Rice case?
Full transcript is here.
Okay.
I had highlighted something, so I apologize.
Oh, sorry. Okay.
Your Honor, for the record, I have 898 Southern 2nd, 1164, Ortega, Mantilla v. State, and 927 Southern 2nd, 146, Curley v. State.
Okay.
So,
What was the second one?
It's the other one I gave you.
We can, I can't find it, I'm gonna pull them up.
H-E-R-I-L.
Do you know the number for that?
Well,
This one I
He gave you something just now?
gave you about 30 minutes ago.
I would suspect this is my weekend reading.
Well, Judge, I'd like to make some
Yeah, go
arguments.
ahead.
So first of all, I would object to the timeliness of this.
I know.
I mean, the defense is talking about unfair prejudice and being biased, and now here they are wanting to argue a Frye hearing in the middle of trial, after the jury is sworn, after they put on all of their witnesses, and after the court ruled pre-trial already that all of this is coming in, and the state went to trial relying on that. So I think that right off the bat, this should be denied for being untimely. Secondly, this is not really a Frye hearing because they're not putting on any evidence. There's no testimony. We don't have the ability to put on testimony for this Frye hearing that we weren't noticed for today, but I would say we don't need to. Under the Ortega case, it's clear that the PCLR is already Frye tested. So that was a Jimmy Rice case. I know Ms. Manuel will argue it's different, but I'm going to explain why that's relevant. The PCLR is Frye tested. The PCLR, Dr. Burston testified, is a test that was developed to determine psychopathy clinically. That's why it was developed, for clinicians to determine if someone suffers from psychopathy. So the PCLR can be used for other purposes. In that particular case, the district court said that the PCLR is Fry tested, and that's a Jimmy Rice case. But what it's Fry tested for is to determine psychopathy. That's the only way that the test can be used. And that's the only way it's being used in this case. No one is saying that this defendant was sane because he's a psychopath. And we went round and round with that in Dr. Burston's hearing. And Ms. Manuel seems to be suggesting that we're using the PCLR to say that he was sane. And we went over and over that with Dr. Burston. He's not doing that. He is saying that he administered the PCLR to measure psychopathy, which is the same reason why it was Fry tested in the case that Your Honor is reading, to determine psychopathy. We are offering that as an alternative explanation to the murder. This is not new science. This is not novel science. Just because they're experts don't want to administer a PCLR doesn't mean that it doesn't apply to this particular case. And I can see why their experts wouldn't rush out and do a PCLR and come back and tell the people that hired them that, by the way, your client's a psychopath. But our experts, when they looked at all the data, they looked at the collateral evidence, they talked to people, that's what they determined, that the defendant is a psychopath, he suffers from psychopathy, and we're offering that as an alternative explanation. They compared his psychopathy to his mental health issues and found that the psychopathy weighs out more heavily in determining why he committed the murder. And I would also argue that that's a pure opinion for both of our experts, for Dr. Burston and Dr. Lazaro, who's also not subject to Fry. They're giving their opinion that he was sane at the time of the murder, and they're going to offer as part of their opinion that he suffers from psychopathy, and that that is part of why they believe he was sane, the same way that their experts offered pure opinion testimony. Even some did testing, some didn't, but they all offered pure opinion testimony about why, in their opinion, they think he was sane. This is also pure opinion testimony. The PCLR has already been Fry tested, so I don't think the court has to make a finding or has to have a Fry hearing. It was Fry tested to determine psychopathy, and that's all we're using it for, to determine psychopathy. No one is going to take the stand and say that because he's a psychopath, he can't have mental health issues at the same time, that there can't be coexistent mental health issues. No one is going to say that because he's a psychopath that he was therefore sane. They're saying that his psychopathy was the driving force, the reason he committed the murder.
And Judge, just to quickly comment on that.
Some of this, just let me refresh my memory before anyone else says anything. that mental health professionals are supposed to be considering a specifier for antisocial personality disorder. PCLR is an assessment tool for features that are consistent with some of the features in antisocial personality disorder. I'm looking at the cross-examination. According to Dr. Burston in his cross, he talks about the alternative model. And he says, they tell you to use it freely, so it's really like one's not good and one's not bad. This is not a black and white issue. And he says, psychopathy is not a diagnosis as a personality disorder. It's a specifier for antisocial personality disorder in the DSM-5, whatever it's called, the alternative, which he says, in his opinion, is an update and is providing additional criteria for clinicians to make a diagnosis. And I understand where you're going, and I agree that the literature I read, it was not used for NGRI. As far as I know, no one's ever presented me with anything that would suggest that the PCLR has been used in a diagnosis correlating with antisocial personality disorder for an insanity defense. But Dr. Burston used it as a tool and was able to reference the DSM-5 alternative assessment to support his position on psychopathy features being identified as part of a personality disorder, and he used a test that, in his opinion, could identify these features.
May I make an additional point?
I'm not done yet.
Oh.
Response to never using information overnight. says further on towards the end that he believes that the PCLR can be evidence of certain personality traits or characteristics in my overall clinical picture. I believe it is an appropriate, clinically defensible, and appropriate use of the test. To say that someone scores high on the PCL and is therefore insane or not insane, or to say because someone is a quote-unquote psychopath, there's no way they could be insane, that would be an incorrect use and interpretation. And then he talks about, in his report, he says there's no reference to Jonchuck being a psychopath. I'm not going to change my ruling. Do you want to say something?
I did, Judge.
Go ahead.
Before we even get to, which I am request, that motion was not to have, that was a request to have a FRI hearing. Before we even get there though, we have to look at the legal relevance. So going to Ramirez and 90.702. If scientific, technical, or other specialized knowledge will assist the trier of fact in understanding the evidence or in determining a material issue. That's important, so a witness with qualified training, experience, whatever, can offer in the form of opinion. However, that opinion is admissible only if it can be applied to evidence at trial. What Mr. Bolin just said in argument, Judge, was that the antisocial personality disorder does not indicate, actually said that being a psychopath does not indicate that Mr. Jonchuck was not mentally ill, and it does, and they are not saying that because he's a psychopath, he was not insane. That makes it not relevant. They are not allowed to call, so first degree murder trial, they don't just get to call an expert to say, we really think this was premeditated. Even after the defense puts on a case and says, there's reasonable doubt, there's no premeditation, they don't get to then call a witness to say, no, but it really is premeditation. Likewise, in an insanity case, they are able to rebut the elements of insanity, the defense of insanity, if the evidence or the information they are seeking to introduce does not make more or less likely whether Mr. Jonchuck suffers from a mental disease, defect, or impairment, or the word?
Infirmity.
Infirmity, there you go. And if that testimony does not make it more or less likely that, well, one, he has to be suffering from that. So it really only can go to that first element. You don't get to element 2 if there is no mental disease or defect. It is not proper for an expert to just come and say, well, I don't think it's insanity, but I think this. Being, I think it was really premeditated or it was really bad. The issue is, does it meet the legal definition of insanity? And if being a psychopath or being antisocial personality disorder or having antisocial personality disorder does not make more or less likely whether he has a mental disease or defect, then that's the end. We don't even get down to, because the second element is, because of that mental disease or defect, he did this. And so, or he was unable to appreciate the consequences and the wrongfulness. So before we even get to the Fry issue, it still has to meet legal relevancy. It would, and if they're not using the PCLR, like they just said, to say whether he is sane or not, it is not relevant. It is not relevant whether it could have been premeditated because he has, I mean, whether it's premeditated or whether he was insane at the time has nothing to do with his personality type. The state has consistently held that they are not introducing they're not arguing any kind of propensity or character evidence, and the court keeps saying that it's not propensity or character evidence, so it's not relevant to whether he was insane at the time. Before we ever even get to the Fry issue, it has to be able to be applied in the evidence at trial and in determining a fact and issue. And so by their own concessions and Dr. Burston's own testimony that it doesn't make it more or less likely that he has a mental illness, and it doesn't say that because he's a psychopath he's not insane, then it has no relevancy. And any minimal relevancy that they could argue with by stacking inference upon inference upon inference is clearly outweighed by the danger of unfair prejudice. The more inferences they have to stack to make it relevant, the less, or the more likely it is that the prejudicial effect is going to outweigh it. In Ramirez, they specifically said, they go on to say that the trustworthy of the expert scientific testimony is especially important because oftentimes the jury will naturally assume that the scientific principles underlying the state's conclusion are valid. And so if he is saying, well, I just think he's a psychopath, and I think that he, well, in Depo, he specifically says.
I'm not worried about in Depo.
Well, he says,
there are going to be limits on, I've made my point about psychopath. And so, and in Dr. Burston's hearing, he agreed with me. So no one's going to call Jonchuck unless somebody convinces me it's relevant in any way, a psychopath.
Okay.
Because it is very, very prejudicial, and I don't know that it means anything. Features of psychopathy are different than calling somebody a psychopath.
But they still have to mean something.
I agree.
And so if they don't mean anything, then they shouldn't be admitted. Just because they're not as bad as calling somebody a psychopath, we're just going to say they have the characteristics of a psychopath, but they're not a psychopath. If it's not relevant whether they're a psychopath, it's not relevant if they have the characteristics of a psychopath.
Well, no one's going to be saying they have a characteristic of a psychopath either.
Well, Judge Dr. Burston has previously said that it's what he thinks is going on in his mind at the time. I think that he's incredibly angry, might have had some grandiosity going, might have had a lot of grandiosity going. I think he was incredibly angry and consistent with my opinion that he's a prototypical psychopath. Another term for prototypical psychopath is aggressive narcissist. He's going to do what he wanted to do. Fuck the cop, fuck everybody, shoot me, I don't give a damn. I'm pissed at the world. The world screwed me over the rest of my life.
Okay, hold on a second. The issue I'm determining is whether I'm going to revisit my ruling on whether Dr. Burston can testify that he used the PCLR to determine if Mr. Jonchuck had certain characteristics that are consistent with antisocial personality disorder, which I believe is a mental health diagnosis in the DSM-5. And he based it in part, his use on the new alternative DSM-5, which suggests that you look at specified, I guess, personality characteristics to buttress your opinion of I'm not a psychiatrist, antisocial personality disorder. And that's what he was using it for. And
I just have one more point.
Judge.
Yeah, but it has nothing, and I don't care what he said in his deposition. I'm making a decision about whether I'm going to change my decision. And I'm not going to.
Okay, can I just put one more thing on?
Yeah.
Additionally, the Florida Supreme Court has said that in applying the Frye criteria, general scientific recognition requires the testimony of impartial experts or scientists. It is this independent and impartial proof of general scientific acceptability that provides the necessary Frye foundation. The burden is on the proponent of the evidence to prove the general acceptance of both the underlying scientific principle and the testing procedures used. And so we don't have, the only independent testimony and evidence we have says that the PCLR should not be coming in. They only called Dr. Burston. They said that the Florida Supreme Court has said that is not enough. And so all the literature suggests that it should not be admissible.
Okay. You had that hearing available to you to call any witnesses that you wanted to. You did not do that. It's the middle of the trial. I think the motion for a Frye hearing is untimely, and I think it would be within my discretion whether I decided to have one, but I don't feel I need to have one because I think I made the right ruling. Anti-personality, so antisocial personality disorder is a diagnosis, and one could make many diagnoses of Mr. Jonchuck and feel that one mental health disorder was more prominent than another, which would, I think, lend credibility to one's opinion that he was not NGRI if these features are part of this personality disorder. So and I think he can testify to that.
So then would it be proper for me to argue to the jury that they can find that his...
I'm not even going there. Well, I'm only going to deal with this issue. But
I don't know how, that's what I'm trying to figure out. If I'm not allowed to make the argument, then is it relevant? So am I allowed to argue to the jury that you could find he has antisocial personality disorder and that's what caused him to do it and that's insanity?
I'm not deciding, and I would probably not limit anybody's closing argument and let...
That would be against case law, Judge.
Pardon me?
Your argument would be... So
is there anything else we need to do today?
Well, the only thing, Judge, just put on the record, Patton v. State, 8787 2nd 368, Florida Supreme Court from 2004. That case certainly suggests that antisocial personality cannot be the basis for insanity, in which case it would make it even less relevant if nobody is able to make that argument. The court's indicating that that is a mental disease or defect, that is a mental illness.
In the DSM-5.
Okay, so I'm just wanting to make sure though, so that it would be relevant and I would be presumably able to argue that.
Well, I'm not going to start, I mean, we could spend days deciding what's going to happen. I don't know, but Dr. Burston is going to be able to testify that he used this test to identify psychopathy, everyone knows the word I'm trying to say, features, to buttress his diagnosis of antisocial personality disorder. He's not going to be able to call Mr. Jonchuck names. There's a lot of things that I'm not going to allow. So if you think those will come up, then we'll deal with it. But I'm not going to preclude him from saying, I gave this test.
And, I would say based on the cases she decides, Your Honor, she's answered her own question. She can't argue that because he's antisocial, he's insane. She knows the answer to that question. The case is pretty clear on that.
So, okay, anything else we need to do today?
No.
Good. Okay, so we'll reconvene at 11 o'clock on Monday, and Mr. Ellis or Mr. Bowman, if you find a case that suggests I made a wrong ruling, I will certainly be open-minded on the statement. Okay?
Thank you, Judge.
You're welcome.
Or for a case, let me know.
I just argued.
Mr. Ellis, do you want this back?
Is this yours?
Can we take this?
All right. Court is adjourned for the day.